to Senior Bounds Live, where today we're joined by Christopher Robertson of Robertson IP. We're going to talk all things intellectual property, from trademarks to patents to wherever we decide to go. Now, none of this show has been pre-recorded. None of this show has been sort of prepared for. We're literally seeing how it goes in order to give you the best content possible. So let's welcome him in. Christopher, welcome. Literally, thank you for just doing this. I asked you, 20 minutes ago?
Yep.
Now, look, I love, me and you have some pretty interesting, we share an office together and we have some pretty interesting conversations. Certainly around intellectual property and copyright and everything else. And I genuinely love the fact that I've got an expert there at hand, because everything you do is kind of potential a copyright issue, right?
That's right.
Every name, every phrase, every statement. So thank you for coming in and sort of sharing a few minutes and talking about the subject a little bit more. So first off, let's just delve straight in with question number one. What is intellectual property? What does it actually mean, and what does it cover?
Okay. Well, intellectual property is sort of an umbrella term for a number of different rights that the law provides, protecting things like your creativity and your reputation. And the most well-known intellectual property rights are probably patents, which protect inventions, trademarks, which protect brands, and design registrations, which protect your aesthetic creations, your repeating patterns, that sort of thing. Copyright, which protects literary, artistic, dramatic works, and even trade secrets, which cover typically technical things for technological companies. They want to keep it a secret rather than make it public, like you do with a patent. So those are the main types of intellectual property rights.
Now, there are certain things, so we'll cover them off first. There's certain things that you cannot trademark and patent, right? Let's go with them. So, because there's only a short list, isn't it?
That's right. Okay. So, I suppose if we start with patents, now, obviously, in order to patent something, it has to be new, it has to be inventive, but there are, even within those limitations, certain categories of inventions which, as a matter of public policy, cannot be patented. And they include things like programs for a computer, methods of doing business, methods of performing a mental act, scientific discoveries, mathematical methods, methods of medical treatment or diagnosis, and a few other categories as well.
So I find that really strange. Why can't you patent and trademark medical practices? Is that because by effectively doing so, you may be hindering?
Precisely for that reason, in fact. So while it is possible to patent a pharmaceutical product, a new medicine, a new medical apparatus, a laser scalpel or something like that, an actual method of treatment cannot be patented. And the reason for that is you don't want a doctor suddenly going into the theatre and thinking to themselves, or more likely in an emergency situation presenting itself, having to stop and think, am I allowed to use this method without infringing somebody's patent? You don't want that to happen. Whereas they've already bought the equipment and paid money to the owner of the patent or whatever in doing so. So there is that very real difference in such situations.
So let's talk a little bit now around trademark, all right? Because I don't know what the percentage is, but I reckon there's probably hundreds of thousands of businesses out there who are trading quite comfortably, quite happily, and have not trademarked their design. Let's talk a little bit about the pros and cons of this, right? So why we have a trademark, but why do we have a trademark? Like, what's the point?
Okay, so a trademark, all businesses have trademarks in the pure sense of the word. So a trademark is any sign which indicates to your customers that the goods or services that you are selling are coming from you and not from somebody else. So they are marks of origin, and their origins are themselves very ancient. Even if they've excavated bricks in ancient Egypt which have the maker's name inscribed on them. So trademarks are nothing new. Now, a registered trademark is one which is on a government registry, and it being on that registry gives you the legal basis for challenging somebody else from using a similar trademark for the sale of similar goods and services such that your customers might be confused about whether those goods are being sold by you or by somebody else.
So let's take probably the world's most famous trademark, which is probably Apple. All right. So Apple, obviously, their trademark is on computers, phones, software, right? But what if I decided to set up a distillery that made cider and called it Apple with their logo? I would still be infringing, right?
You probably would. Now, obviously, cider isn't something which is even remotely similar to computers, smartphones, iPods, all the rest of it. But there is a provision in law for particularly well-known marks where they can be enforced even against trademarks which are similar and for completely different goods and services. So they'd be able to stop you in that sense. It would be interesting to see whether you could even register the trademark Apple for cider, because one of the restrictions on trademark registration is that it can't be descriptive of what you're selling. And since cider is derived from apples, it would be an interesting thing to think about.
Yeah. Okay, because that brings on to another thing. So, so our business is Senior Bounds. You are Robertson IP, right? Actually, yeah. So you're Robertson IP. So, but you trademark?
Yes,
obviously. Okay, I'd be pretty surprised if you haven't. But surely your trademark is descriptive because you are IP. That's what you're doing. So were you able to trademark that, or were you just able to trademark your logo?
Well, I have trademarked my logo just because that is the get-up I use, if you will, in my marketing materials. But it's my own name which confers distinctiveness on my brand. So the Robertson is not descriptive of the services that I provide.
Okay.
And that's where it comes from.
Fantastic. So, so a couple more minutes to go now. Let's talk a little bit about patents. Not patents, which is what I often call it. It's a patent. What is a patent? What does that actually do, and how does it protect us?
So a patent is protection for a technical invention. So something which you have designed to solve a particular technical problem, make something better, make something easier, whatever it might be, a new widget, or whatever it might be. So it's a document which describes in detail your invention, in so much detail that somebody else who works in that industry could make it after reading your description. And then a set of claims. The claims define the monopoly. So these are worded in legal and technical language so that somebody reading that claim could tell exactly what they are allowed to do and what they are not allowed to do. And that patent, if granted, will last for up to 20 years. And during that 20 years, in the jurisdiction you've got it patented, you can control who disposes of your invention anyway. So you could stop people selling your invention without your permission. You could stop them making it for sale, and you could even stop them importing it from overseas, even if you don't have a patent in that other country it's coming from. You could even stop them, if you find out about it, from flying it through British airspace, if you've got a British patent, or through British waters, in order to be sold from one country where you don't have a patent to another country where you don't have a patent. So there is quite a lot of protection involved in a patent.
It's bonkers. Okay, I mean, I don't know any of that, I'll be honest with you. Even with our in-depth conversation, every time we talk, Christopher, I learn something new. So now let's just very quickly, just to finalise it off, let's talk a little bit about the TM, the R, the C. What do those three symbols mean?
So TM indicates a trademark, and it doesn't have to be a registered trademark. So if you're using anything as a trademark, which is to say a sign which indicates the origin of the goods and services that you're selling, then you can put a little TM there. If you've registered your trademark, then you're entitled to put RTM or R in a circle. You can only do that if you've registered your trademark. It's a criminal offence punishable by a fine if you falsely claim to have registered your trademark. And C in a circle stands for copyright, and it's just a shorthand for copyright. So if you are marking one of your literary, creative, dramatic, artistic works as copyrighted, then you can use that as a shorthand. So typically one would mark one's copyright works with copyright, the year of creation, the owner of the copyright, all rights reserved, just so that whoever sees the content knows that you intend to exercise your rights with respect to that particular piece of work. Copyright, of course, is automatic. So as soon as you make a record on a creative work, then it is protected.
See, that's awesome, because copyright is probably what causes some of the biggest debates when it comes to this sort of thing, right? That's my work, that's his work, so copyright and IP is very, very important when you're looking, especially within the design world.
Yes,
IP, intellectual property, and copyright. And to be honest with you, mate, I think we need to do a show just around IP, because there's just so much to it, isn't there? Let's just give it a quick overview. What is IP? What is intellectual property?
So intellectual property is the protection of your creativity and your reputation. It comes from that fundamental sense of fairness that we've all had since we were even in primary school, that it's not fair if somebody copies my work and takes the credit for it. That's ultimately what it is.
Fantastic. So, look, we do have to end the show. I always find the conversation with you very intuitive. I really do. And I love having those conversations with you. So, if you were to give anybody listening a single top tip around, they've got a business, let's take the startup businesses first, right? So someone's got a business idea. What would be your top tip?
I would definitely say go onto the IPO, that's the Intellectual Property Office government website, and have a look at all the resources on there, which are free for small businesses, because there's a lot of information there which can just help stop you shooting yourself in the foot inadvertently when you're starting a business from an IP point of view.
Fantastic. And then a top tip for someone who is they're an established business, they've been going for a few years, they potentially got their trademark, or maybe they haven't. What would be your top tip for those type of people?
It would certainly be worth them investing in an IP audit, just to have a look at what they've got, what they could potentially have, and what they should be doing about it. It can identify some really quick wins, which can add a lot of value very quickly to their business.
And then someone who, say, has an established business and then is looking to franchise that company, what would be a top tip for those people when it comes to registration?
Well, they certainly need all of their intellectual property ducks in a row. They need their trademarks registered, and they need to have a very clear idea of what they own intellectual property-wise, particularly around their processes, their systems, all of that sort of thing. So again, an IP audit, perhaps in slightly more depth and perhaps directed towards preparation for a franchise would be a good idea.
Perfect. And then I think the same kind of goes for a company that's looking to sell their business. I'm assuming that would be very similar, because effectively that's what you're doing with franchise, you're selling parts of your business. But for a company that's looking to get out of their business, they're making sure that all their ducks in the row can add a lot of value to their business.
Absolutely, yes. Every intellectual property right that you register is an asset which, which your business owns and which has a value attached to it. And there is an element of unregistered right to the selling of the business as well, because the chances are, if you've been operating for a number of years, there's a certain amount of goodwill involved in your business. So you need to make sure that that is covered in the transfer of rights along with everything else. Otherwise, it just could lead to problems.
Fantastic. Listen, Christopher, it's been absolutely brilliant having you on the show. Obviously, if anyone wants to find Christopher, you can do so by going to the Senior Bounds platform and literally just typing in Christopher Robertson or Robertson IP. But how else can they get on?
They can find me on LinkedIn. They can email me, christopher@patenthelp.co.uk. They can find my website, which is patenthelp.co.uk.
Fantastic. And that's all we have time for. So massive thank you to Christopher for joining us. And we look forward to speaking to you again soon. Take care.